collision. Defendant also failed to signal lane changes and had an expired registration and moved in the lane several times. A traffic stop was initiated. An officer observed defendant to have droopy eyelids and glossy pink eyes. Officer also observed a moderate odor of alcoholic beverage from defendant's breath. Standards of sobriety tests were conducted. 6 out of 6 HGN, 5 out of 8 walk and turn, and 2 out of 4 one-leg stand. A breath sample was provided and results were 0.108 and 0.100.
Does he have any prior DWIs? Does he have a license?
No prior, I remember his license right now.
Okay. Mr. Dyke, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, then I will revoke the bond, put you in jail. No more PR bonds for you. This is not a revolving door. Do you understand?
Sure.
How old are you, sir? Do you have the ability to hire a lawyer?
Yes.
How do you support yourself?
Look at the server, restaurant.
Okay. Deputy Williams will give you an application. I need to know how much money you have coming in. I need to know other household income, and I'll take a look to see whether you qualify. You're not allowed to drive unless you have a valid Texas driver license and liability insurance. You must maintain car insurance. If you don't have it, then likewise, do not drive. You understand?
And Your Honor, his license is eligible.
Great. All right. We'll have you fill out the application. You'll meet with Ramona. You'll sign conditions with Veronica, and then we'll have you take a seat, sir. Hi, good morning. Are y'all splitting again?
Over to Sean's cases.
So the beginning, you got the end. Okay, cool. Easy to remember. Okay, we're talking about this. Mr. Harry, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On May 25th, 2026, officer was dispatched to residence and met with the complaining witness who observed the defendant at her residence. The complaining witness stated the defendant had been on her property approximately 3 times and had been invited by the witness without complaining witness's consent, and she stated she is the primary owner of the property. Officer observed the defendant sitting in the trunk of the vehicle that was in the complaining witness's residence driveway.
Sitting in the trunk.
Yes. That's what I have in my DIMS. The defendant stated he received a ride from a security guard to the above residence to get some of his items that the witness had in her bag. The defendant stated he does remember receiving a warning, but believed it to be a warning of not returning if he caused a disturbance.
Do you know the relation? Is there any at all or no?
Can you repeat that?
Is there any relation or do you
I
know?
believe that, the witness, is the daughter of the complainant.
Got it. Okay.
And was dating the defendant.
All right. Mr. Harry, I'm going to find that there's probable cause to go forward with your case. Your only condition is to not go back to this house. Do you understand? I'm not asking much from you, really. Just don't go back. You can meet somewhere else. Just really. Do you have the ability to hire a lawyer?
Yes, sir.
What do you do for a living?
Just wanted to call it, mortgage.
Okay, we will give you time. I'm going to have you sign a reset and then I'll have you take a seat while we get bond conditions. Come to court. Don't wear shorts.
Yes, sir.
It's a complete sign of disrespect. I mean, really, this is a courthouse. You're not going to. You understand?
Yeah.
Okay, please. So, oh, I'm sorry. If you can file conditions, please do not go back to the house,
Okay.
please.
Megan?
Yeah, I got it. right, Ms. Liggins, you're charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, Mayor.
May 25th, 2026, officer was dispatched to an apartment complex in reference to an assault occurred / injury. The officer observed a blood trail from the lobby to the parking garage, where the officer found defendant sitting inside a storage closet covered in blood, and there were cuts on defendant's hand, right leg, and feet. Defendant stated she had a fight with her boyfriend at his apartment, and he had pushed her twice to get out of the apartment, and she had knocked over a candle, which is what caused injuries. Officer then met with the complaining witness, who stated he and defendant were at a pool party and are dating. Complaining witness grabbed his cell phone that the defendant uses and saw that the defendant was texting other men. Complaining witness left the area to get picked up by a friend, and complaining witness and defendant got into an argument, and he found his vehicle to be destroyed and believes defendant is the one who did it. The officer observed damage to complaining witness's windshield, smashed multiple times, kicked in one side, and driver's side window broken. And the officer observed blood on the vehicle's hood and on the passenger window. The officer concluded the injuries defendant sustained were from damage from the vehicle.
You've got A and you've got C, but you don't have B. Does anyone see her do it? Do you have video doing it? Do you have a kind of blood sample that shows it's her that did it? Did the officer take the next step to see if there's video inside the parking garage?
That I'm not sure about. It does say here complaining was that he and his friend drove to his vehicle after the argument, and that's when he found his vehicle to be destroyed, but I do not have any other indicators of it.
I need more. It's just not enough. It's assumptions, hunches, and I get it, right? Car's destroyed. It's got blood on it. She's covered in blood, but do you have anything else?
Just a moment.
Sure. Mr. Bell, your client has a bond violation. Hall.
I'm checking that.
Tiara Hall. She here?
I can see her, yeah.
She's supposed to be here.
Yeah.
This is for the first time. Right, what I'm doing is the officer observing the damage to the vehicle and observing the injuries that the defendant had and concluding
Yeah.
that it was consistent with the vehicle. That's all we have in this.
So
Trying to pull up.
Miss Liggins, I mean, pull up the OR if you have something else, but I mean,
No, there's nothing wrong with that.
That's it? Okay. Ms. Liggins, I'm going to find that there's no probable cause to go forward. However, it's very possible that they go have this case indicted if they get more information. So you need to be on the lookout. It's very possible that a warrant issues. Do you understand? Take a seat for me, ma'am.
There's no.
Judge, it's his middle page, third.
Okay. All right, is it Tizeno? Speak English, sir?
Yes, sir.
Mr. Tizeno, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
May 25th, 2026, officer observed a vehicle continually straddle to the left and right lane and continually weave within a single lane of traffic, causing other vehicles to slow down and move to other lanes. The vehicle was accelerating and decelerating from speeds within 55 miles per hour and 66 miles per hour. The vehicle also had a defective license plate light and an object hanging from the rear view mirror, obscuring the windshield's view. A traffic stop was conducted. The defendant was in the driver's seat of the vehicle, and the officer observed glossy eyes and a strong odor of alcoholic beverage from the defendant's breath. The defendant admitted to consuming one margarita. Standard view sobriety test results include 6 out of 6 HGN, 7 out of 8 walk and turn, 4 out of 4 one leg stand, and defendant provided a breath sample with results being 0.142 and 0.132.
Does he have any prior DWIs? And does he have a license to drive?
He does not have any prior DWIs, and I am checking his license right
Please.
now, make sure it's eligible.
Sir, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. No more PR bonds for you. Do you understand?
Yes.
You will be tested for illegal substances, including marijuana. If you test positive, it's not going to go well between us.
He does have valid.
You're not allowed to drive unless you have a valid Texas driver license and liability insurance. You must maintain car insurance, and that is also a condition. If you don't have it, do not drive. You understand? Do you have the ability to hire a lawyer?
Yes. No. No.
How do you support yourself, sir?
I work.
Great.
Yes.
Doing what?
I'm a commercial mover.
Okay. And how much money do you make a month?
They're paid by the hour. The rate by the hour.
On average, how much money do you make a month?
A week, at least 2,000.
And who else do you support? Do you have any other household income?
My mother and my baby, the newborn baby.
Deputy will give you an application. I need to know everything about you, who you live with, what kind of income the other people that you have that live with, and I'll take a look to see whether you qualify. We don't give out court-appointed lawyers like it's candy. You have to qualify, meaning that you're at the federal poverty guideline.
Okay.
Don't put zeros, otherwise I'm going to send it back to you. Do you understand? You will meet with Veronica for your bond conditions. Do not use alcohol or illegal drugs. You understand?
Yes, sir.
Okay, come on.
Lopez. Judge, this is Lopez on page 14.
Is this the last one?
Yes, okay.
Mr. Lopez, you were charged with terroristic threat.
Judge, this is-
Oh, Mr. Lopez, do you have a lawyer today? Does he have a lawyer today? Does he have a lawyer?
No.
What have you done to look for a lawyer?
Can you give me some time so I could
Yeah.
find an attorney?
We will give you another reset, but your case is getting old. Have one by the next reset, please. We will have you head on over to Ramona. We'll have you sign a reset. And when you come back, please have a lawyer. Thank you. I'll speak louder. I'm live streaming.
Rich, how much time?
Just normal reset. THA. Yes. Crazy, right? Okay, we need to pick up. Hi, are you ready?
Morning, Judge.
Please, come on up.
Oh, Docket.
Okay, what's your cost number?
It is 262.
Okay.
1343.
Okay,
Mr. Rugen, you were here just the other day for his arraignment. He and his mom want to plan a trip for a couple days and I wanted to.
not a problem, just that it's a
He doesn't have geographical restrictions, but he does have random testing.
Sure.
So I wanted to see if it was okay. He could be excused the days he's out and then tested.
How long is he going?
I believe 5 days, including travel days.
So yes, but tell him that we have a test that goes back, not to use. If he does, then he will go to jail. So I don't care where he's going. I don't care how festive it is,
Right.
just not to use. Yeah, just, and we'll waive it, signature. Yes, ma'am. Okay.
Thank you.
Okay, just let me know that we did. Okay, thank you.
Here,
Yes, sure. Which. She can continue to know, and when they get down to the day, like, so great.
The arrangement.
you have another arraignment? Yeah, for sure. Hey,
Briefly,
yeah, of course.
should say, I have a Zapata Junior that was our Liberty County guy that just still hadn't gotten broad degree yet.
So do you mind, oh, we have Zapata who's on the docket. Now, I guess what I'm gonna do is I'm just gonna issue a warrant because we just don't know when he's gonna get out, but at least that way we'll put the hold. And then if you want to stay on it, you can. If you want to withdraw, you can withdraw. You tell me.
No, I want to stay on it. I like.
Okay.
this.
Okay, so can you tell me when is the evading prior to or is
Prior to, it was MHA.
I
So-
hope the meeting in 2024.
do you know if anything happened? Can you see a disposition on it?
Yeah, let me read the history to see if anything's changed.
So 2501. So I'm just gonna move 2501. And then I guess we'll see. I don't know. That way they don't have to keep bench warning it and we just last on the docket, about that, 2501. He's in Montgomery County Jail. And we just don't know when he's gonna get out.
And that's it for your probation, that's what I have. I don't see anything other than that.
Okay. I guess we'll just give you a heads up when we end up getting him,
Thank you, Judge.
for sure. So we did get a phone call, right? About your. Yeah, if you get any more, just let me know. And then I'm gonna start writing the phone numbers down and then I'll give it to the sheriffs. Um,
Okay. Me.
Oh, yeah, yeah, I'm sorry.
Thompson?
You say Sampson? That's Thompson. Ms. Thompson, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
May 25th, 2026, officer was dispatched in regards to an assault. Upon the officer's arrival, the defendant was hysterical and irate. When her parents walked around the rear of the house, the defendant started to speak louder and did not want the officers to speak with them. The defendant's father stated that the defendant was upset because they cleared out her items from the garage, which is when these defendants started to throw items all over the backyard. The defendant's mother stated the defendant started to throw items on her father, including a lamp. The defendant then grabbed a brick, but placed it down, then grabbed a wine bottle and told her father, "I'm going to hit you over the head with this." The defendant was told to remain outside the residence, but she said she had to leave to go to work and that she's going inside and the officers cannot tell her what to do. The defendant had walked away from the officers and attempted to walk through the back door of the residence. The officers grabbed the defendant, who did not comply and resisted. The defendant was placed in handcuffs, then she dropped her weight, causing officers to have to pick her up and place her in the back of the patrol vehicle, and she then started to kick the back door of the patrol vehicle.
Was she under arrest?
Um. I believe they were still conducting, their investigation when she was told to wait outside, which is when, this had all started. But, it says here, then through the information that the caller gave dispatcher about the defendant was assaulting a family member and grabbing a brick and throwing all items on the floor. The officer believed a physical altercation occurred and one of the defendants separated. And at this time, they did try to place handcuffs on her.
The information says did then and there unlawfully with criminal negligence, namely entering a residence during a criminal investigation after receiving instructions to refrain from entering the residence, interrupt, disrupt, impede, interfere with. I thought you said did he tell her to go into the house?
It looks like, they had told her to, they had told her to remain outside and then she had proceeded to go inside. Which is also what the charging instrument alleges happening, to refrain from entering residence.
Ms. Thompson, I'm gonna find that there's probable cause. I'm not going to put any conditions on your bond. Just be careful, ma'am. All right. Do you need a lawyer?
Yes, and I.
Stop. Don't. I'm gonna give you a lawyer. You will with a lawyer, because the problem is you have the right to remain silent. If you say something, they're DAs, they're gonna try to use it to prove your guilt. It's just, now's not the time. I'll give you a lawyer today. Tell everything to the lawyer. The lawyer can fight for you to try to do what they can. Okay. So please, I'm trying to help you. I'm trying to protect you from saying something that you don't, right. So let's do this. I'm going to have you sign a receipt with Ramona. We'll have you take a seat. I'm going to find you a lawyer, and then here momentarily, we'll have you talk to the lawyer. Okay? Please. You know, give me one second. Give me one second. Clearly, that's a mental health crisis. You know what I mean? And they just arrest when. I'm sorry, Carlos.
No, you're fine.
What's up, man?
You know, we have Mr. Castillo, latest Castillo.
Okay.
We have been in the process of PPI, I believe we submitted the last notice, I think they're waiting for. So we're gonna ask.
We have our deputy chief right there. She'll give you a response now. The deputy chief right there. I bet you she'll give you a response right now.
Yes, sir.
If you don't mind just asking that way, is your client here?
Yes, sir.
Great. So if she says yes, we'll send him for a TRAS now and then you're in the home stretch, you know?
All right. Sounds good.
Just if you don't mind to ask, if she says she more time, then I'll give you a couple days.
Thank you very
Yeah,
much. sir.
for sure. Hi, yes, ma'am.
Okay.
Yeah, I'm client board was reporting on Friday afternoon.
Okay.
On a protective board, and we also have a family, it's one of the film for Jersey. Jersey currently allowed him to remain in the home because the complainant is no longer living in the home.
Do you have a cause number? Please.
Yeah.
What? Hey, Veronica, will you look into Gaunt? They filed 2 BVRs. They look like they're identical and then they never send an email. Do you mind just looking over? Okay, what is it?
Card number 2026.
2026.
3094.
Nope, that's too many numbers. Maybe take,
I have the family law card number.
no, I need the criminal number. Or if you have a spin, maybe for that one? No, it's a different case.
Okay.
Okay,
I have 2619.
that sounds better.
Okay, 0730.
Wait, 073. That's it. So he's got 2 counts of assault of a family member, right?
Yes, yes.
And you're saying the complaining witness does not live at that house anymore? Okay. Have you been able to verify that? I think this is your case, right? Yeah. Horn? Okay. So today's her first day. She's getting caught up on everything. If we verify it and they're able to determine after speaking with the complaining witness that they're no longer there, then I'm happy to do it. But I'm not going to take their word for it. I need them to verify it. And once they do, then I'm happy to do it for you and we can scratch that provision off there. Yeah, so.
To verify that, I can step out.
Sure.
Now.
Yeah.
Oh, for the family? Yeah, for the family law. I'm not supposed to call.
Yeah, I mean, we need to,
Thank you.
yeah. Mr. Bell, you ready?
Yes. You know, all the oil authorities.
OL, right?
Oh.
Okay. Okay,
I believe we wanted her to check in, see if she's looking for jobs. She hasn't looked at jobs, she applied to 40 some places. She hadn't received an interview yet, though. That was 2 weeks ago.
Miss Alford, come up. You have had 14 days and you've done 4 applications. It needs to be 44, not 4. You will have another 2 weeks. If you don't have at least 25 in by the next 2 weeks, it's not going to go well between us. Do you understand? Okay. See you in 2 weeks. If we don't have it, it's not going to go well between us.
Thank you.
All right. Thank you, Mr. Bell.
Yes.
Right. On Miss Oldford, did I say no alcohol and no illegal drugs? Please. Okay. Hey, I'd like her tested within the next week or two, please. Hey, hey, it's not the club, man. Okay, is she gonna send an email or no?
I'm not sure if they're gonna send an email, but, there should be one still up that is, there's.
You mean one of those BVRs?
So what BDRs is saying, it's just a duplicated BDR.
Got it. Okay, thanks.
I was able to, get in touch with, hopefully, that's possible.
Okay. She's not living there anymore?
No.
Great, okay, then, I'll go ahead and amend it. I need the cause number again. I have to write it down. Oh, do you have it? Yeah, what is it, please?
611-073. And I have the new address as well, if you want to, I don't know if you want to change.
Yeah, I guess if you're gonna file a new one, well, he's probably not here.
Oh,
So what I'll do is I'll print this out. I'll take that one out. And then if you want to put it on a sticky, because I'm live streaming, so it doesn't go over the entire thing,
right.
then I'll manually write it in to the other one. Yay or nay?
Yay.
Yay, wonderful. So we'll send it for a walkthrough, then we'll give you 2 to 3 weeks to finish it up.
Thank you, Chair.
For sure. Is that one?
Yeah.
Great, thanks. Sebastian, you ready? Hey, good morning. What's up?
She didn't make it up on that point, over there, talk to her, but, I just signed on last week.
Did you say Baker?
AKJR,
I don't see it.
in the jail docket.
Oh, I see it now. Okay, I was,
So I just, the age of the gates and the little.
dang, it's old.
Right, I just signed on to it, last week, but, she didn't make it up for some reason today, so I'm gonna go chat with her, but.
I bet that they're, let's see, what else she has. Okay, so she picked up a felony
Yeah.
case.
No, I signed on to her when she got.
Do you sign on to the felony cases as well?
I just, my office represents a felony, but,
Okay, whatever if you want to set it the
yeah, I mean,
next,
as far as I understand, it's always complete and everything, so I'm assuming it's just, I think. The clock.
for sure. Yeah, okay. That was Akbar.
Yes,
Okay.
so it's gonna be, the survey is completed.
Yeah, he's just gonna reset it because she didn't make it up. Maybe she's still in processing or whatnot. I don't know. So, great. Veronica, on Gaunt, the defendant does not have a lawyer and the supervising officer did not send an email. I'm looking at the signature and I have no idea who that is. Can you find out, please, who's supervising officer so I can attach them to an email asking them to reach out to him to let him know to come on Friday? Please. Okay, what is it? Ah, is it last name first?
It's, it's silent, so it's
I got it. Is it Ashley dot? Right, I'm gonna CC you on this in case I get it wrong, okay?
I said what happened. She said,
Okay,
okay.
it's okay. I'm sending an email now.
Karina? Yes. No, no, it's not like launch. Just double check it. Was this done? No. It's still. You're on the record. I would. You can find the usage, as soon as they. So, at 3:30, I think we have text something and we're gonna buy this. That's the only reason why that's so fast. Getting the puzzle out of this. And then, do you mind just? Order and I'll just do that. Yeah. Okay. Writing it in. I like to listen. I'll see like this video, because I can. You can. Really? I was like, thank you.
I have it right now. I'm doing it for you. So here, if you want to come, that's that, and then.
Thank you. And then, have the state sign as well, Judge,
Oh,
have the state sign as well.
I get, yeah. Do you want to, do you mind? Because that's a good idea, just in case. You
Eric.
just initial like where I.
Just.
And
Okay, and then, and then.
Amazing. I want to make sure that we know. Hold on, that on. That's just. Well, I know. Anyway. You came to actually eat. We've got it for 299, you know. Did you see what they're talking? Gordon's, the Lambert and Martinez. It got the assault by body. That's their video. Steve reported. He's been instructed, watch him first, if you want to. And they have this result. For sure, and I've been. You know. Yeah.
Hey, Colin, can I talk to you real quick?
Don't change them.
A motion to amend the indictment for information was just filed on your client meeting list. Did you know about this? Yeah.
It's right here.
Abraham Morales?
Yeah.
Yeah. Yeah, so it's gonna be up here, sticking to one.
So they're adding on the 0.15.
Did you know that? That's not.
No, that's fine. No.
Okay.
Because it was Dan.
Yes.
Before we had that, they just didn't actually, so when everyone had, it's gone.
Here's the.
What are we doing then?
Yeah, he said.
But if he's printing at 50 days,
It almost carried away, so I didn't want to.
but it's a 90-day minimum, right? So they're abandoning the Berg Hab, but they're leaving in the 0.15. Is that right?
Right, that's fine.
Okay, because then that would make it just a solid year, right? And then he could plead to the 50, right? If they kept the Berg Hab in there, then it's a 90-day minimum. Okay. Do they, who's,
They're all, we talked, if I talk, all three.
Farwa,
I cleared.
can I talk to you? I guess I should have had you up here. So you filed a motion to add the 15 to meet Ellis's case. I guess for Logan did. Looks like Logan filed it. Did you talk to Logan at any time?
No,
Weird.
that's strange. I didn't, like I said, I didn't know about that, like.
So on meet Ellis,
That was the one that followed it.
got it. Okay. You're good with the enhancement of the Berg Hab excuse me, being abandoned,
Yes, sir.
but we're adding in the 15
So
allegations.
it looks like Mr. Logan.
Yeah.
I'll say his last name, had filed a motion to amend back in March.
Yeah,
And
that's, okay.
yes, and
That's
then
what I
I
was
saw that
wondering.
the
is-
offer was already as a 0.15.
Okay.
So I thought that it was already addressed, but then when I talked to the
Okay.
clerk, I was. Yeah.
Well, no, not good, because we don't have it done. But let me think of-
You said it's one.
Okay, you sure?
Yeah, yeah, sure. I mean, as long as I know, I mean,
Okay, no.
yeah, you don't have to write it. Um, I just saw it. Did you send it to them too, right? Okay. Hey, are you ready? Hi. Good morning.
Good morning. Okay, so I have Mr. King West. This is a situation where an 18-year-old picks up a felony involved basically within weeks. Reduced down to this week. He picks up other cases like the next week. It's now June 2nd. I'm wondering if you would be willing to offer him.
The bonds are set now.
Okay, I don't.
They're all set at 5,002 because so he's on bond for the felony assault. Does he pick up a jail assault? Because oh, no. Okay. So it looks like he pleads to the assault 3:30. 7 days later, he picks up an assault. Then 2 weeks later, a mischief and an evading arrest. So he's 18. Tell me about
He
it.
had some physical issues as well. I think he was diagnosed with anxiety disorder and explosive personality disorder.
You say explosive personality disorder? Oh, man, that's
Yeah.
far
It
too
seems weird that
common.
all of this is happening within like a 2 week time frame.
Who's in his life? Who's he got? You know,
He's homeless.
that's a problem. Deputy Williams. Can you bring someone up? Mr. West? West. Let's talk and figure out.
Talk to ADHD about
Well, that's a good idea. Yeah. You know, maybe they have the reentry with the at Emmett Center. At least so he can know what they have available and when. I guess let's talk to him, see what he's got. But if he's homeless and Etch, he's got a warrant. Cannot go. So is she still in? How do we
You
know?
might from her hospital beds.
No.
And she said, okay, so, there's that.
It's on docket today.
Yes.
This was Bali.
Oh.
So she just sent you an email, or I don't, did you attach her?
Actually. This is foster mom. And then I don't think foster mom is cooperative. I'm not sure how long we're gonna give her. It's been several months.
Why is she there? Why?
So either way, this one, then you might have to go try. This client got pregnant the last month.
And she's already? She's already after only a month?
No, so she's having pregnancy complications. It's not related to the case. It's just,
Sure.
she's just having a really bad. So I think that there's a risk that for the rest of her pregnancy, she'll be in health. Oh, she's already been in done 3 or 4 times.
How long do you want?
I'm always here, you know, I can come in every week.
Well, just are we delaying the inevitable, right? What is she, at some point, she's gonna have to take care of this better now versus when you have the baby, you know, because it's just gonna be even more troublesome when that
My
happens.
position is at some point, we'll have to take care of this. We still don't have a roof.
Oh, that's a problem.
The mom is, I think she's welcome.
And we did attempt to rip, we just haven't heard back from her, but.
Is it a Spanish rep?
No.
That'd be great.
Okay, so let's set it off 2 to 3 weeks, okay? I'm gonna set up a bond forfeiture. Because I want to know what's going on with her and then just let me know, okay? Yeah. Okay, yes, ma'am. Good morning, Mr. West. How's jail? What's better, free world or jail? Why do we have jails?
Yeah, just because we keep everybody in the road system where they can get out of here and they time eventually make a difference. If everybody can make that difference, I'm here to make my plea, plead my case.
No. Why do we have jails? We have jails because some people, when they get out in the free world, they just go crazy and they don't act in accordance, right? There's a certain way. We want our public safe. We don't want stuff broken. We don't want people in danger. And when someone turns out where they just continue to pick up case after case after case after case, it shows that there's some issues. You pick up a felony case, gets resolved. A week later, you pick up an assault. Then 2 weeks later, you pick up 2 new cases. Stop. I'm not asking you to say anything. I want you to understand why we are doing what we are doing and why we have jails. You understand? The problem is how do we go forward? Because obviously we're not going to keep you here forever. Who do you have in your life right now? Who's out here to help you out? You have parents around? Where do they live? I mean, they live here in town. Do you get along with them?
Yeah.
Would they be willing to take you in? Why? Speak up. I can't hear you. So they just want you to follow some rules.
Yeah, but it's not even the rule, it's just, I was so rebellious, it's what it really like. I didn't really know.
So tell me, what's better, jail or rules with your parents?
It's all the same, everything.
Really? So you like jail then?
I'm speaking the truth.
I get it. I get it. But is jail better than living at your parents' house with some rules?
Yeah, his parents' house on December 3rd around his birthday. He's been just wondering for about 3 months, and that's when he started picking up his case.
You know, your parents are supposed to love you forever and forever. I can't imagine that they're asking much from you. Wandering the streets of Harris County, they will eat you alive. Oh, Mom, come on up. I'm sorry, I didn't even know that you were here. How do we go forward?
Taking big steps, we're gonna get them the help that we need to do better. I love my son and I speak with my son every day. I tell him, when he's here, come see me.
If she didn't care for you, she wouldn't be here, Mr. West. You know, I can't imagine she's asking much from you. Is he taking medication or is he supposed to be taking medication?
Take anything, I've been trying to get him help, for a lot of things that's been going on with him that I've been getting. And I've been trying to take him to, he went to a, counseling place, I get some help there, they just see anything wrong, they just feel it's something he's probably going through. But it escalated over the years. And
Take your hands out of your pants.
And it got worse. And, I just didn't know how to deal with it. And, yeah, so the city takes care for him as well. So I put him in covenant home, to put in place because I didn't know what to do. So then other things happened with him, not being at home. We just led up to him being here.
So we have a mental health division within the district attorney's office. Not we, they have a mental health division. What we're going to do is we're going to try to go through them to see how we can have him evaluated and to see how we go forward with this case. We're not here to just do our worst. We want to help and we want him to leave better than he came. My fear now, if I let you out, you're just going to run amok. And that's not what we need. The last thing we need is you to pick up a couple more cases or a couple.
He's been prescribed Elozapine, the biggest goal, and they've been getting that in the gym.
Wonderful. Great. Why don't we just set it maybe like a week so we can start working fast toward a resolution? My only problem is I would be happy to give him a PR bond, but the feeling is that if I let him out, I don't think you can control him. And I think that he's gonna just do whatever the heck he wants to do and he'll just start running around. And that's what I don't want. I don't want him to just, once he starts taking it, we start getting stabilizing, we start doing well, and then boom, he gets out and runs back to the same old.
You give them a GPS monitor with a curfew, Josh? She's willing to take over from me.
I'm going to have my fucking phone with me. I'm willing to take.
I know, yes, I know this, but how can we get him to stay? That's the problem.
Get him in a place that will help him. I would support you to do that and step wherever he has to go to make sure he's there, get it necessary help if he needs.
Come up with a plan first, and then I will acquiesce to you. I don't want to just let him out with, okay, well, we're going to do this, we're going to do that, we're going to do this, we're going to do that, yet, and then nothing happens. If you have a system or if you have a plan in place, okay, we've set up an appointment at this place. This is when we're going to go do this. This is who's going to see him. This is how it's going to get, paid or not paid because, we need to figure that out as well. I'm happy to do it. We can set it 2 days, 3 days, however, but I get a lot of people that tell me, okay, we're gonna do this, we're gonna do that, we're gonna do this, we're gonna do that, and then at the end, nothing happens because they're not. So I will acquiesce you. I'm not saying no, but I want something concrete in place first, and then we can address it. In the meantime, do you mind reaching out to,
Yes, I'll reach out to ABA others to get in some sort of mental health.
okay? How soon do you want to do this?
I
do
can
you
do that right
think?
now.
So we may be able to get something set up now.
Yes, we can.
We may be, so just give us a little bit of time. She may be able to work something now where they get him into a diversion program where he'll go to the Emmett Center so they can learn and see what resources are available. And then, yeah, let's do that and let's see.
Okay.
Okay,
I'll reapproach.
ma'am, thank you for coming. Yes, ma'am. Hey. Who's first? Okay,
For general stations on the older side, not over 180 days yet, but it's getting there.
180 is the magic number. 180 is cleared trial.
Okay.
So
So we need to,
it's 178 days. What do you want to do?
get in.
Okay, so is he need a mitigation packet?
I think those in the accidents,
There's no accident, it's 0.12, so I don't believe so, but the last note I have here is, it'd be a tier 2 approval position, so
Say it again?
it'd be a tier 2 approval position.
Okay. Is your client here now? Can you ask him whether that's what he wants to do?
it is, we already talked about it.
Great. So I'm going to set you for a week to get the application done. And then he needs to be here and then we'll send him for a TRAS. Okay?
I do have one more.
Okay.
Rodriguez.
Okay.
For him, he was previously denied for PTI, but we did send in some additional information. I was only able to send in the medical information this morning, so she did let me know that she needs a little bit more time to view it.
So this-
Caitlin, the hospital, we said.
Okay, you're at 190 days old. I'll give you until the end of the week.
Okay.
Shouldn't take that much longer. So, Thursday or Friday, and then, okay? Your client needs to be here as well, if it's either or.
Yes, sir.
Okay?
Thank you.
Yes, ma'am. Hi, Colin, you ready?
Good morning, Jeff.
Hey,
Good to see you, Jeff.
how are you? Mr. Haggard, always a pleasure.
Always good to be here.
Mireles, come up. Is this a true first? Good morning. So you are Mr. Mireles.
Correct.
Sir, you were charged with driving while intoxicated. You were facing up to a year in jail and or a $4,000 fine because of the high blow. Looks like you have worked out an agreement where they're going to offer you 50 days in jail with credit for the one day that you have done.
Yes,
Is this how you understand the agreement?
yes, correct.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This DWI will go on your record. It will be there for the rest of your life. Your record, it's not very pretty. Every time you get pulled over, what are officers going to do? They're going to look at your record. If they smell alcohol, if they smell dope, what's going to happen?
Come back.
Very big possibility. The problem is that from now on, it's a minimum of 90 days in jail. Do you understand?
Correct.
I would never, even if you have a sip of alcohol, don't get into a car. It's a huge risk. Is this what you want to do?
Yes, sir.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty? I'm going to find you guilty, sentence you to 50 days in jail, give you credit for the one day. I'm going to suspend your license for 90 days. Do not drive until you get a license, and then we will take him into custody now. Okay, all right. Thank you. Good luck. CC. Mero mero.
Mr. Laska?
Laska?
Laska, LASTRAP.
Oh, Lestrap.
Uh,
Yes, we know Mr. Lestrap well. How's Mr. Lestrap doing?
He's doing well. We got an offer for 30 days on the new, that case, but he's on currently on probation. He took a 1 year on this felony case. I was wondering if this court is okay with terminating probation.
What do you mean on the felony? Because it's with us. He's on probation with us.
Well, that's okay.
You can 2-year probation on the evading, and he just took a 12 month plea of extraction.
He took a what?
12 months, 1 year plea, 1 year Harris County Jail plea, but he's on probation. You know,
He has 3 cases, felony and 2.
Okay, so I guess I'm gonna match the time upstairs then, you know? We'll give him credit for everything. He'll run at the same time as upstairs, you know? Yeah, I guess if you want to write it up, let's do the same thing. Yeah, we'll match what they're doing upstairs, whatever. Yeah, okay.
we're doing for the evading, we're matching.
How much, do you know how much credit he had in the felony case? No, let
No,
me see, hold on.
as long as we're running concurrent, that's what he wants.
Wow, hey, it was a 2nd degree reduced to a state jail. No, the theft from a person, it was a 2nd degree reduced to a state jail. That's a big reduction. So they gave him a year, Harris County with 35 days credit. So why don't we do 300 with whatever credit he has, that'll end up matching. Yep. Okay.
The 300, how much, however much credit he has to be.
37.
300.
I don't know. We'd have to see what he's got here. Ours will be shorter than whatever's upstairs anyways. So did you see Henry's new one?
Sorry?
Did you see Henry? His new turbo. That thing's sweet. It's what dreams are made of. He posted it on Facebook. It's wonderful, man. Oh, about the office. Yeah, he was such a great guy. I mean, he's just, everybody loved him. He'd come in all the time, say hello, and did you know him? He was great. Well, they ended up charging the dude. Just 3 little girls. That's right.
Well, good to see you.
Yeah. You guys all right?
I think they take time to look at us. Going in here. I'll see you later.
Yeah, take care. Mhm. Dude, no, because you got to do it fresh and do Thursday. Yeah, it's an old game. Do Thursday. They appealed it, they appealed it a while ago, they're just waiting for the decision. Hey, hey, don't. They're having a conversation. You don't need to be in it. Please, that's the second time I've told you. Hi, Mr. Cunningham.
Totally off topic.
I'm live streaming, just so you know.
You what?
I'm live streaming, so that you know. Do you want to talk him back?
No.
How are things?
Is there, I need to scan a document onto a USB. And
Can I scan it and email it to you? Is that okay?
scan it and put it on.
Let's go look. I don't know. That. And one.
So now we should. Some of your buddies.
Which one is Thompson? Is that the interference? No. Ramona.
Yeah.
She's a big she has the here the last from the property sector.
Did you want to make a flag?
Yeah, he just left.
Okay, wait, I'm not-
Don't make sense.
I show us, because you should be. Then we were thinking possible, I give it to you. Okay. Tracy, do you have any more?
No.
Yeah, I have, no, last one's just that one.
Okay.
Oh.
I deleted that accidentally. Yeah, accidentally. Okay, then, yeah, if you don't mind, print that out. Or I guess save it, or put it in the queue by chance. At least print it out so we can have ready. If so, did a song to show up or no? Then it gets removed. No, nope, she got BDR, she's supposed to be here. Okay, hi.
Good morning, Judge.
Good morning.
This is my, you can on.
Good morning.
We're here for bakery.
Another,
Resign waiver.
resign, okay,
This was
wow,
actually a refusal now, but concerning the resign waiver.
well, it is what it is.
But they're on locals, so we're resetting for locals after to July 15th. So this is just.
So not eligible, oh yeah, they've not made bond. Okay, all right,
Thank you.
Thank you.
yes, ma'am.
Judge, wondering if this is.
What? Okay. No, let me go, yeah, don't, just give me 1 second, and then I'll take it back. Yeah, hey,
Hey Judge, how
what's
are
up,
you?
what's up?
Approaching on an off-topic matter.
Give me
Um,
your cost number.
Cost number is 2610-614.
Okay,
Approaching the modified bond conditions, Judge. You had ordered him to get the interlock device in his vehicle. On that day, he told you apparently that he didn't have a vehicle to put it in. You ordered it anyway to get it within 7 days. Tomorrow is the 7th day. He doesn't have a car, so.
well, you picked up a DWI,
No, what I'm asking is, if he didn't have a car to put it in.
whatever vehicle he picked up at the DWI.
Oh, no, that car is scrapped apparently. He said he scrapped it for parts.
Great,
For whatever
but
reason.
we don't have proof of that, and I can't take his word for it.
Well, my question for you is, can we stick to a portable device?
But the problem is that he may still have the car, and I don't know.
Okay.
You know, I need more than just, by the way, I don't have the car anymore.
Well, he told you on the day apparently that he didn't have.
Yes, I'm not disagreeing with you,
Right.
but a lot of people will say, I don't have a car, and then they pick up yet another DWI.
I
That's the
understand.
problem.
My problem is that he's not gonna be
If
able to.
he
put
scrapped
into
it, bring me proof.
Okay, but he's not gonna be able to do it by tomorrow. And I won't
That's
be
a
here
problem
tomorrow.
because that's a second bond violation for him.
What was the first bond violation?
I want to say, or maybe it was a different person where
This is a brand new case. He got conditions last week.
Right.
So they're gonna file the BVR and I'm gonna put him on the docket probably for Friday. So he's gotta be here at some point with some kind of proof that he no longer owns the car.
Okay, can we hold off on the BVR filing to Thursday? I'll be back on Thursday.
I mean, if he's, say it again?
I won't be here tomorrow. My whole thing. I'll be back on Thursday here in court. So can I just put him on the docket for Thursday
For sure. Yep.
and then bring him here
Yeah.
and then you're on.
Yeah, yeah.
At that
Yep,
point?
yep.
Okay.
But he better, just telling me, everybody tells me everything. Everybody tells me I've got hair like both of us. You know what I mean?
Well, you got
And
more
then-
than I do.
Well, maybe a couple strings.
So on docket, he's trying to get your license.
Damn, I'm tripping. Hey, come on. Good morning.
Good morning. This is on, Mr. Hernandez.
Okay.
Hernandez Villarreal.
Jail?
No, he's.
Oh, I see it. Okay. Tell me, what's up?
So this was the case that's being treated upstairs.
The judge is
Okay.
always like,
He actually-
"Hey, come to big crack people."
Up here, so as soon as he gets transferred to the new court, he's ready to take the deal. And it includes dismissal of his current case here in, this court.
When?
Those are the ones you cannot have or you can.
Right now, there's no date. Right, for his next court date.
And this case is 4 years old.
I've been on the case since February.
How on earth can it not have a date?
I don't understand the mechanism for it's being transferred from one court to another. This is 2033, it's the next court. I know that's not real, it's just a placeholder. Correct. But he got this off on yesterday.
So what's reasonable? What's a reasonable timeline that we put on the case, you know, that we say either done or done, you know?
I would.
What do you think?
I don't know the district clerk's transfer thing about it.
But all it takes is one judge signing the transfer order and that's it, really, you know, and, well, no, I don't want you to do that. Because I don't want, you know, but at some point we gotta put, so I'm asking, what's reasonable, you
I
know?
would think 38, I don't have any clue, I'm just throwing a number.
I mean, so your case, you've been on it for 4 months now, right? Okay. I'm gonna give you a 45-day trial date where if it's not done within 45 days, I'm putting him to trial. But it's through actions of his own that this case has been open since 2021. And because by then you'll be nearly at 180 days here, right? I mean, at that point,
That's fair.
if it's not done upstairs within 45 days, if it gets done earlier, then they'll off docket dismiss it here and then you don't have to worry about it. But if they have it transferred within 45 days, and I mean, it really, then just who knows when they're gonna do it. They're just. So pick a date.
Thank you.
Yep. Okay.
Yeah, we request for the judge.
What's up?
So for the bond case, my only question, Your Honor, is can we extend the end date or due date? This
He
must be done
needs
by
to be
tomorrow.
here.
Well, no. You want him to get it done by tomorrow, 5 p.m. If not, BVR gets filed.
Correct.
My question is, can we extend the end date from tomorrow, 5 p.m. to Thursday, 5 p.m.? That way the BVR never gets filed. So like, what I don't want is if a true.
So, no, that's not fair. If a person has a BVR, it needs to be filed because they've not complied with the bond conditions, because then if they have a second BVR,
That's my.
then it's, no,
that's
then
my
I'm,
concern is I don't want the ever second BVR.
but if he has a BVR, it's got to be filed because it's only fair. I cannot treat you differently than I would treat anybody else. If he has not done what he's supposed to by a certain date, then a BVR gets filed, and it happens with every single case. And I'm not gonna, so
If I email.
we will still talk. I'm telling you, we can talk about it on
I just
Thursday.
want BVR to be filed. That's my.
But if it is a true BVR, then it's got to be filed, because then what's going to happen, like what happened on the other case where, well, it wasn't a true BVR, but it really was because he didn't get it done within the time that he was supposed to, just like every other person.
I hope we're not talking about the other case. That one was different.
I get it. I understand. And I didn't hold it against
it.
him, but, right. But I mean, if it's a true BVR, it's
Right.
got to be filed, because you cannot continue to have issues and expect good things to happen.
Okay, so then so as soon as I walk out of this court, I'm gonna.
Don't commit me. I don't want to commit
No,
to
no, no.
anything.
Well, you want proof is what your honor
Correct.
requires. So if he sends me proof that the vehicle was sold with the same VIN number and all that kind of jazz, if I send it over to.
If he brings me something on a bar napkin, we're gonna have issues.
That's not what I said.
Right. But I'm saying, if he shows me, okay, I sold it to Punka City Auto for $15 and
That's not what
on
I
a
said.
bar napkin that has a beer stain on it and it's got a cigarette burn on it.
Listen, Judge. Contracts on a bar napkin.
But if it's legitimate,
You know who got signed on a bar napkin? Lionel Messi.
Well-
Messi got signed when he was 7.
Homeboy's
years
not
old on a
Messi,
bar
man.
napkin. He might be. Give him a chance.
if it's legitimate and it looks like it comes from something that's
A scrapyard. I mean, I imagine. it'd be a
right,
scrapyard,
then
because he says he's
we
full
will
of
address
scrap.
it at that time. But
Well, I've already got him on docket for Thursday.
great. If
But
he doesn't
I've
get it
also
done,
proven- I'll try to get it sent to him like this afternoon, tomorrow morning, so that the BVR never gets filed.
that's on you. But we still need to talk about it, because
He's on docket for Thursday.
regardless, he's supposed to have it on by a certain number of time. If he hasn't had it on and he waits until the last second to address it, that's on them. So you
Well,
can't,
He called me on Friday about this, and I told him as soon as you make your first payment, I'll sign on to the case, I'll get
Sure.
it started. So he made his first payment yesterday, and now I'm here.
I get it. Okay.
So, okay.
Okay.
I'll get her email address and I'll send that information. to her.
Okay. But if it's not done in time, a BVR gets filed, just like with everybody else. Shanae, are you ready?
Yes, good morning, Judge. How are you?
Hi, good morning.
I'm here on Jaylee Wilson.
Wilson.
Yes, Judge. And Ms. Wilson the state is accepting a PTI on Ms. Wilson. She was delayed in getting me some of the information. I just wanted a week or two to put it together and submit it to the DA's office.
Sure. Okay. Your case is 160 days old, so you're getting up there.
I understand.
We'll
I
give you
plan to
the
have
two
it
and a half
resolved.
weeks, but at that, there's no more waived appearances, okay?
I appreciate that, Judge.
Bear with me a second, I'll get you a date.
Sounds good. Thanks.
No, help them. They're there first.
Just to be clear, we would consider a PTI with the mitigation package.
Oh, you would consider.
Yeah, that's what I have in my notes. There was never an agreement for it.
So you heard that, right?
Yeah, I heard that, but the conversation that I had is that she needed to just submit it, and I'll confer with the state judge, but I'm intending to submit it anyway.
So this is your case, Farwell, right? Okay. Bottom of page 33. So 2 to 3 weeks must appear. They're applying for a PTI.
Okay.
June 18th.
That's perfect.
Okay, it's yours.
Alrighty, thank you, Judge.
Okay, yes, ma'am. Have a good day.
You too.
You too. Anna.
Good morning, Judge. I'm here on Garcia. He's on today's jail docket.
Garcia on the jail docket. Tell me, what would you like to do, Anna?
Well, so his misdemeanor was set for trial on the 30th, June 30th. But he's picked up a new case.
Oh, Lord. So I'd say we still go, right?
Okay. Okay, that's fine. I just didn't know if you wanted to do anything else
No,
with him.
no. Just because he picked up the felony doesn't mean anything. We'll still go. He's just in jail, though, you know?
Okay.
I guess I'm going to end up revoking the bond as well, though, because he picked up a felony case.
Well, I was going to ask you to do that anyway, so he gets credit. So,
Deputy Williams, do you mind bringing up Mr. Garcia? Garcia, please. Guys, you ready?
Yes.
Talk to me while we're waiting.
You're on Shannon Hall.
Okay,
And,
it's only 4 days.
yes, I was approaching for her bond conditions. She has the interlock device and the portable device.
Okay.
Right now.
Sure.
I spoke with pre-trial and he said that she's in full compliance, so we're just asking to see if we can get that portable device removed.
I don't know. She has a BVR. She had a BVR. She tested positive, right? So I have a. We have alcohol in the car.
Yes, there's an open container of tequila in this possible.
What was, did she take a breath test or blood test?
Yes, there was a, blood test, which was 4.3.
No,
Okay.
sorry.
Had to ask.
I know.
Had to ask.
Thanks.
Thank you.
Just so you know, you're not here alone. Your lawyer is here with you. If you look on Zoom, she is right there. So you, Mr. Garcia, are on bond for an indecent assault, or I'm sorry, an indecent exposure. You were set for trial when?
She's 30.
June 30th of this year. You have now picked up a new case, a felony assault of a peace officer. I'm now going to revoke your bond on this case and I'm going to set it at 5,001. We will still keep the original trial date, so we will put you to trial on the 30th of this month on the indecent exposure, but you cannot pick up felony cases and expect. Do you understand? Okay, so I'm assuming from now until the trial date, your lawyer will come and chat with you so you guys can get prepped on the trial. Do you just want me to set him for that day? Do you want me to set him earlier, Anna? You tell me.
let me,
Can
can we
bring him
leave
here
him?
to talk to him? I'm cool with it, so.
Okay, well, can we leave him on the 30th and I'll go to the jail and chat with him, sometime this week.
Okay,
And then, if we need to adjust, I'll, let Victoria or Ramona know.
so be ready for trial, right? Yeah, okay.
Okay.
Okay, or I
Okay.
guess it's not yours, it's, yeah. Got it, okay. All right, thanks, Anna.
Thank you. May be excused.
Yes, ma'am.
Okay, have a great day.
You too, take care. Bo,
Hi, Judge.
what's up, man?
Not much. I have a Mr. Aparicio on your docket today, Your Honor. I was asking for a reset.
Your case is 190 days old. I need to know what you want to do, man. Clear
They just
trial.
they just made an offer, Your Honor, so we can set up for a plea. My client said he'll take it.
Okay, we'll give you a couple weeks.
Okay.
Hey. Anything?
Give me a second, Bo. I'm gonna get a date.
Yes, sir.
Yeah. Gotta get some balls. Yeah, it's sure. Yeah, you know what? I literally just came out with kids, man.
They left you up here.
No. This is.
So that's like. Because they sent it then.
Hey, so on Aparicio, just two weeks, 2.5 weeks. Plea, set it for a plea, 3 weeks. Yeah. Bo, are you good with the 18th?
Yes, sir.
Okay. Your client's got to be here, okay?
Yes, sir.
All right, man, have fun.
Thank you, Judge. Good seeing you.
Hi. Thank you for being patient.
Yes, sir.
We had a lot of people waiting. So, what's up?
No, Mr. Sweet.
Mr. Sweet, come up. I guess you don't get the message. You're now on your third bond violation report. I have let you go over and over, and we continue to have bond violation. If I let you happen in 2 weeks, I don't care. You have bond conditions, and it's a third bond violation report.
Information, even though it's technically a third, it's really not, because the last one, remember, it was confirmed that the device was.
Okay, sure.
Was malfunctioning. And even on the first one, remember, there was an issue with him just not being able to put the device in the vehicle because the wife works for CPS. And so she drives clients around all day, and so that was the issue with that. So changing things first.
We continue to have issues with Mr. Sweet over and over and over. And this case is really only 50 days old. And it's just over and over.
Well, I guess that's the point. We really
and over.
not really have an issue. Now, this is really the first. The other two were really. I actually remember when I was assigned to him, he was trying to kind of explain that situation.
Mr. Payne, let me ask you this. When he picked up the DWI, was it in the wife's car?
No, sir. It was in a rental vehicle.
I asked for proof of that, right?
No.
I did ask for proof.
At one point, and then that's when we had she had a discussion, and because the asking for proof was to give him something other than a portal. But then
I understand, but
talk to the state, and then they said they will find with a scrap. And at that point,
I want to know with 100% certainty that the car that he picked up the DWI was not the wife's car. My concern is that I don't want him to have access to any car that doesn't have an interlock on it. So if he picked up the DWI in the wife's car, I'm going to have issues.
Right, well, there was no, this vehicle had Colorado license plates, you know, so.
Which one had Colorado license
The
plates?
vehicle that he was, arrested in had Colorado tags. So his wife was out resident of Texas, but if I had known, I could have had that information for you a while back, but once we kind of came to the consensus that you would allow scram, that's the only, I would have presented information to the court. So if that's an issue, then that's on me because I was aware that I needed to provide at that point.
I want
But we can certainly.
100% proof that the DWI he picked up was not the wife's car, number one. I like to send him for a drug and alcohol test now. Mr. Sweet, you know, I have children and my children drive me absolutely up the walls. And when I tell my son, don't do something, and he does it, and I say, don't do something, and he does it a second time, I say, don't do something, and it happens a third time. When I threaten him with punishment and then I don't take on the punishment, what do the threats mean? They mean nothing. I'm never going to have this discussion with you again. If you ever have another issue, and I don't care if you are 1 minute past, if you're 2 minutes past, I don't care if there's a unicorn out there or Jesus tells you to do something different. If you ever have another violation, it's not going to go well between us. Do you understand me? I don't care about excuses. I will protect my community at all costs. If that means throwing you in, you understand me. Okay, I'm going to send him now. I'd like to also know, so we'll set it for Tuesday for another hearing to see about what happens with the test. But I would like by that time to know definitively whether the DWI, the nature of this case was in a different car than the wife's car, because the idea is that any car that you have access to has an interlock on it. Do you understand? Take a seat for Mr. Sweet. Hi. Good morning, Mr. Burns. You ready?
Yes, Judge. The motion for return of property in your queue was considered you consider it. In case that had been dismissed and the state does not object to it.
Is it a gun?
It is a gun.
Do you have proof that the person, the gun is their gun though?
Yes, I would submit it to the state, I would submit it to you.
Who looked at it? Ms. Batista or who? So was she able to verify that the serial numbers matches and everything?
I previously submitted it to the state, but I'll do so again.
Just make sure that, because I've given back property to the wrong person before, and then I had people come here just.
I can imagine what nightmare.
It was a true nightmare. So that's why now I make sure that if I don't have a problem giving it back to you, but I want to make sure that the person who owns the gun is getting it.
I'll do that right now. Thank you.
Which, thanks. You too. Hi. Good morning.
I have 3 people on docket today.
Okay.
So we start with William. She's here. She's on bond. She needs to sign her bond condition.
Okay, sure. Anytime. No, I guess when it kind of dies down, we'll just have her call her up. If they're bond condition with Veronica, right? I don't
Yeah.
remember.
Okay, and then I also have Payne.
The conditions are don't go, the theft, where was the theft from? This is your case, right?
Yes.
So did you draft conditions on this?
I do not believe, I did have the magistrate's conditions.
Okay, so here we go. Right, she had, let me make sure she signed it. She's got it signed. It says here, don't go to any Bath and Body Works, and then no going back to La Toxica.
Okay.
Right, she's got it signed, so you're good.
Okay.
Yeah.
And then I have pain
Pain. Jail or bond?
in general. This is the case we had set for last week. The state wanted time to evaluate the case to see if we can possibly make it without the complaining witness. I do see that a few attempts were made again, and there's still no answer for the complaining witness. So my position is dismiss, or we're gonna set the trial today. But we can call it. Because I did take a look at the case, I just haven't had it. I mean, we're gonna set for trial, set for trial or dismiss it. I mean, there's no complaining witness.
Okay. I guess
So.
just, and when we're done, I guess if you don't mind seeing, just eval it without it, you know?
I emailed him, just want to talk
Okay.
about the case of it, because this, you have the trial day before. I would just like to discuss it.
Okay, yeah.
Okay.
She
I
just
don't
needs a
have to
couple
bring
minutes.
up coach If I need a trial date.
You got it.
Mr. Ramon.
Of course, I'm okay with
Thank
it,
you.
sure, of course.
All right, and then the
Last.
last person that I have on docket is Mr. Ramirez. He is in jail.
Okay, so essentially, if you're not going to dismiss it, they're ready to set it for trial today. So it's either all or nothing, basically. Okay, so Mr. Ramirez,
Yes, can we get a probable cause?
sure. What, it's a resisting,
This is Robert Ramirez.
so on both or on which one?
They came out of the same transaction, so it's the
Okay.
same DIMS. And if
Right.
we can read the actual DIMS and not the summary. I'm gonna read from the DIMS on this one. On May 30th, 2026, in Harris County, Texas, officer was dispatched to a welfare check. The report he stated that a male had broken inside into her mother's residence and made threats towards the reportee's mother and broke into the residence. Officer attempted to contact her but was unable to get in touch. I'll just read the whole thing. Just word for word. Yeah. From the beginning, my belief is based on the following affiant is a certified peace officer employed as a patrol officer with the police department. I have a good reason to believe that on May 30th, 2026, in Harris County, Texas, Defendant Ramirez did commit the misdemeanor offense of failure to ID as a fugitive and resisting arrest. On May 31st, 2026, affiant was dispatched to a welfare check at 7619 Baltimore Street, #1, Houston, Texas, Harris County. Based on the call slip, the reportee had stated that a Hispanic male, 44 years old, had broken inside her mother's residence and had made threats towards the reportee's mother and had broken into her residence. Applicant later attempted to contact the reportee via a callback, but she was unable to get in touch with the reportee. Officers on scene noticed defendant Ramirez matched the description that was on the call slip and attempted to retain defendant Ramirez, who was in close proximity to that 27619 Baltimore Street, Houston, Texas, Harris County, about 3 to 5 feet away. Defendant Ramirez was seen leaving on foot from the locations. Officer was also advised of violent tendencies that defendant Ramirez had displayed by the call slip. Officers on scene then attempted to detain defendant Ramirez based on his matching description and due to officers' safety concerns as violent tendencies have been mentioned in the call slip. These violent tendencies included threats to report his mother and breaking into the report his mother's residence. Defendant Ramirez been multiple times, chose it looking out the way, as step away from the officers as officers attempted to place defendant Ramirez in handcuff restraints for about 30 seconds. Initially.
For what? For what? He's leaving, right? So it's not can't be a trespass.
Right, I don't believe it says he attempted to leave.
He was not on at the location, he was from close proximity, so he wasn't even a threat.
3 to 5 feet away. He was found 3 to 5 feet away from the location.
Like, so they go there to investigate whether there is an issue, right? They get there, mom's not there, he's not there. They see someone matching the description, but the person's going away. So at that point, anything that was happening has dissipated.
He was 3 to 5 feet away from the residence when he matched the description.
Okay, she's not there, and he starts leaving.
In the description, Judge, it was a 44-year-old Hispanic male. There's a ton of 44-year-old Hispanic male.
Bring it.
In Houston, Texas.
Bring it.
Sorry, I'm just kind of factoring because there's a California extradition at some point it's going to be mine. So was the argument that he couldn't have been trespassing because he would already left the scene? The issue right now is.
Oh, no. We don't even know if that's the case.
Right, but that's the point, is at the time of the initial detention, right, before it evolved and developed, is that they were investigating the trespass, and as it pertains to the slip, is that he broke into the residence, and trespass, there's two ways. One is failure to leave and one is forbidden entry. And the latter is what we're arguing, is because at the time that he went for the welfare check, it was a forbidden entry, not a failure to leave. You are correct that there is nothing pertaining to refusing to leave in this fact pattern, but there's another statute in criminal trespass where he did not have permission to enter in the first place. And as it pertains to the initial stop,
How do you know he's even in
that's
there?
the point, is the report, assuming that is true, validating.
There's your problem.
No. Validating the call slip for the initial breaking in the residence, that's what they have to go on, and it didn't have anything more than the description and the call slip, and that's the purpose of the investigative detention. As it involved to the resisting arrest and the failure ID, that still cannot be done until the initial forbidden entry, which is valid under the statute, under a different criminal trespass statute. And so you are correct. If it didn't flesh out, if it turned out the mom did permission, we would have never filed or considered criminal trespass. That's not what's being argued here. Is the initial detention as it pertains to a call slip and forbidden entry part of the statute. That's what they were investigating that developed into the other two charges. And so I believe it's valid because at the time of the stop or at the time of the welfare check, at that point, the only information that they had was forbidden entry and that this person matched the description. That's all they need to initiate the investigation. They don't need the full end part of it until they complete the investigation, which they did, that they developed into the charge.
So, when you go for a welfare check, right, you're going to see, is there someone in peril? Is there some kind of danger? Is there something aloof afoot?
Yes.
Right? You get there and everything's fine.
Sure, but we don't know that. And that's the point. At the time they stopped them, they didn't
But the law doesn't work on hunches, though.
It doesn't, and I'm not asking you.
Right.
At the time the officers approached, right, there's nothing stating that they've already cleared the house, that they've already spoken with the mother, that there's surveillance video, there's an independent eyewitness, there's nothing pertaining to the initial breaking in the residence that invalidated the officer's suspicion. If there was something else saying 14 different people.
What about the fact that she's not even there?
But that's the point. They don't know at the time of the initial approach. They don't have all the information and they have a justified reason to at least make the investigative detention.
But he's leaving.
Yes, but
He's leaving, so.
I'm not disagreeing with you, Judge. He is leaving, but that doesn't invalidate the initial detention. We are not saying that he is being arrested on that alone. That's not what we're saying. That is an investigative detention, which is permitted by law for the suspicion of forbidden entry criminal trespass. Nothing else is happening up until that point other than investigating the initial call slip for the forbidden entry part of the statute. And if it turns out that there was nothing further, then you're correct. Would have been released if he didn't give a false name, if he didn't give a false date of birth, if he didn't have an extradition warrant out of California, that would have ended right there. But then it evolved from that investigative detention into other criminal charges. And that's the distinction, is that we're not independently charging him with criminal trespass. That is just the initial reason for the stop, which is validated on GWIs, on many other things. The initial detention is not dispositive for what can come out.
What do you think?
Judge, I do not even believe that this will rise to the reasonable suspicion for the detainment. He was 3 to 5 feet away from where, in what location, 3 to 5 feet in front of the driveway, in front of the door, across, I mean, that's 3
Where
to
did they
5
get
feet,
him?
and then also.
Where was he?
The description says a 44-year-old Hispanic male. There could have been other descriptors. My client has tattoos. They could have said that. They're literally just said a 45-year-old Hispanic male. There are a ton of 44-year-old Hispanic males that can be 3 to 5 feet away from this residence in this area of town. So I don't even believe that it rose to the reasonable suspicion even for the initial stop.
3 to 5 feet, where was he?
The evidence does not specify where, but it does specify that he was in close proximity to the listed address.
And if it's a neighborhood, then there's older houses that he could have been in close proximity to, 3 to 5 feet from the next door neighbor's house. I mean.
So I'm gonna interject, what council is wanting in terms of the full picture is not required by case law. In terms of what is provided that is sufficient for the initial detention is distinct from what would be the perfect picture of what should have happened, right? We don't have a ring camera, we don't have a full biographical description of murder. That's not required by case law, that's not required by statute. For the initial detention, it is sufficient for identifying this individual close enough that the officer made a stop, and that part has been proved. And so what they want versus what needs to happen is very different. And so the distinction is important because yes, we certainly would love surveillance video from everywhere. We would love to have a biographical database of every person for every reason suspicion. That's not categorically possible. There was sufficient information to identify this individual close enough for the location that the investigative detention was sufficient.
Pursuant to the four corners of the names, Judge, I don't believe that there's probable cause.
Can an officer, if they get a call that there's something going on in a house, the person matching the description is there, can they go up and talk to the person?
A vague description.
There's just, sure, I mean, officers are free to go up and talk to whomever they want, right? They can, it's just up to the other person to decide.
That they said anything to him other than it goes from, they see him 3 to 5 feet away from this residence, and then it jumps to, he's being put into handcuffs.
Did they ask him or did they just find him and put him in handcuffs? Was he walking while Hispanic?
Yes.
Okay. Okay.
Did they just go up to him and just arrest him on the spot?
Taking a look at them, Your Honor.
They detained, they didn't arrest. But detained,
Officers,
again, is not.
well, they attempt,
Did they put him in handcuffs?
they attempted to detain defendant based on him matching the description.
They put him in handcuffs?
And Judge, may I read from the DIMS?
Okay, just, did they put him in handcuffs right then and there where they got him?
They attempted to detain defendant. They attempted to place him in handcuffs because of not the description in the
Okay,
court.
I'm gonna find no
And
problem with
officer
cross.
safety.
They attempted to, but they didn't put in handcuffs immediately. This is the moment that he became violent, that they.
I was under the impression that they just get up to him and then immediately put handcuffs on him.
No, Judge, so it says that they attempted to detain him based on him matching the description of the officer safety, but at that time, he became violent. He multiple times attempted to pull his left hand away and stepping away from the officer. The officers attempted to place him in handcuffs, restraints for about 30 seconds, and that is when Officer Otero attempted to put him in handcuffs, restraints, but defendant continued to resist officer.
Did they attempt questioning him
No, Judge.
even?
When they approached him, Judge?
No, it does not say that. It goes from officers on scene that attempted to detain defendant Ramirez based on him matching the description and due to officer safety concerns as violent tendencies have been mentioned in the cause slip. These violent tendencies included.
Let's do this. I'm gonna set it for a hearing tomorrow morning. Take a look. Do you have body cam on it?
This KPD, so we should have body.
Looking
For
at.
Take a look.
probable cause, are we sticking to the four corners of the DIMS? Because based off of the four corners, there's no problem.
I want to know, what I'd like to know is, did they go up and at least attempt to question him? Hey,
That's not
you
stated in
know,
the DIMS, Judge. And that's what we're basing our probable cause on, that's not stated in the DIMS, so now we have to, if we're gonna go outside
When
of the
they
DIMS
say-
and look at evidence, then that's different.
When they say detain, it means that they're going, they've stopped him, they're trying to question. And at that point, if they give false information, then
I don't want the court to go in a different direction in terms of, and I understand where you're coming from, Judge, but part of the call slip as it pertains to this individual is, as far as the information that they collected, it did indicate that he had violent tendencies. And for felony stops for a myriad of reasons, and there's case law supporting this, is if they have anything in the call slip or the history articulating violent tendencies, previously assaulted an officer, whatever that is believed for officer
but this
safety.
is this a felony stop?
No, but it said violent tendencies, which again, case law has supported. If it is articulated that an officer's safety is concerned by what the information is remitted to them, that it is not inappropriate for them to take measures for their safety. This is one where it's not blind, right? And this is an individual in a random.
Know that?
They didn't even ask him his name, just based off of the description, which is extremely vague, they could have asked Mr. Ramirez what his name was to
Well,
confirm that that was him.
but that's
Then-
what I'm asking you
Judge,
to.
correction. In the office report, it does say that when they saw the defendant, he began to walk away, they began to speak to the suspect while his partner Vasquez went to speak to the mother of the caller. So they did attempt to talk to her.
He said he was living on foot. Officers were also advised of his tendencies. It says officers on the scene that attempted to detain defendant Ramirez based on him matching the description. So if we're reading from the DIMS, if we're gonna go outside of the DIMS, then that's completely different.
I
And
don't
we
know
can set
what,
that for
but I
hearing, or
don't
we
know
can
what
use
it,
evidence.
I don't know what attempt to detain means.
Based how the DIMS reads, it states that they saw him 3 to 5
Let's
feet
do
away.
this. Let's do this. I've got a line building up. Let me get them out and then I'll readdress it because I don't want them to sit and wait. They've been waiting long enough. Give me 5 minutes. Let me get them out and then.
Judge, can you check the way?
But who's Belinda? Hi, thank you for being patient. Come on in.
On page 13.
Hi.
The
Okay.
client, I have the pleasure of appearing before you.
Yes, nice to meet you. Who you got?
I'm appearing on behalf of Miss Destiny Navarro.
Jail?
Yes.
Okay. Mr. Kim.
Your Honor, she's one out of Letitia Parish, Sheriff's Office in Louisiana for a failure to appear on a negligent homicide. I will be opposed. This is not one where this is an arrest warrant where she was unaware. The case stems out of 2023, and she failed to appear the arrest warrant issuing there on January 2026. This is a fatality case, Your Honor, and I believe it will be appropriate.
Is it,
She's refused, and so.
is it a life case?
No, it's not.
No?
The Louisiana statute for how it's.
I spoke to Ms. Navarro, she said that she had no idea about that she was supposed to be in court. She has been living in Houston for the past 6 months, but all of her ties are in Louisiana. She has transportation back to Louisiana and would ask for a reasonable bond so that she could travel to Louisiana and take care of this there. She has a 6-year-old child who is financially dependent on her. And, but does not have any source of income.
I mean, so she was on bond for this and took flight?
I don't, well, she had notice, which is why failure to appear. I don't know if she approached the setting, but she had notice, which is why it's listed as a failure to appear. So at some
I
point,
mean,
someone
it's a
from the.
2-year-old case and it's a homicide case, you know?
Yeah. It's my understanding that this is a 2B warrant. She has not appeared.
If I were to set a bond, it's going to be very substantial just because of the nature, you know?
Based on my discussion with Ms. Navarro, she has limited means.
Right.
So I would ask your honor to allow her to go ahead and can we file the waiver?
Sure, of course. Yeah, I mean, if she's ready to sign
Yeah,
it,
she would be ready to sign that in.
you know, and let her know, it's Louisiana, you say?
Louisiana.
So once she waives, within the next 3 to 5 days, she'll be back probably.
Alright.
So, yeah, just let her know it's gonna be substantial.
Alright.
Wait,
So
yeah,
if she
sorry.
signs the waiver, she has to sign it to turn to the court and the judge will sign. We don't have to read it, but she has to be the one that signs.
Okay, alright. And I have nothing further.
Okay,
May I be excused?
nice to meet you.
All right, nice to meet you.
Ms. Batista, Mr. Burns, Ms. Batista, were you able to confirm they match?
Yes.
Yeah, okay, I'll grant it for you, Mr. Burns,
Thank you, Judge.
for sure,
Appreciate that.
of course. Hi,
Good morning.
how are you?
I am well. My client is on docket today. He did come in voluntarily. I just happened to be in the building. Mr.
I thought you were on a trip.
Not yet. I did. I went to Chicago. Well, I went to Waukegan. We went to go to the
So you're back?
yes, we went to the Navy base. We needed to bury my partner's grandfather's ashes. We found that. So it takes a while to get the reservations, to get everything set up to the So that's when we were out there for this week. And not too much party. Just a little bit of,
What are we doing with Mr.?
He did, like I said, Your Honor, he did come in voluntarily this morning. He informed me that he did want to take care of this. He apologized sincerely. So I have been emailing this morning with the DWI and Henry. And she just also emailed as well. We've been waiting on a contract for a few hours. I've been in and out throughout the morning.
So they're gonna honor the programs?
Yes, they
Wow.
Got the contract.
you got it.
Got the contract. We just need to get it signed.
Okay,
Okay.
all right, well.
Just because the reason why I did is because it's.
I'm kind of-
He's here today, that's the only
but
reason why I told him.
I gotta say, I'm really reluctant to reinstate his bond because he does nothing but play games. He's been playing games since day one. That's all you do is play games. You play games with everyone. Play games with us. You play games with your lawyer. You play games with everybody. So I have enough drama in my life. I don't need any more. And the only thing that gets you to do anything is when we issue a warrant. It's like, come up. Like a little child. You know, there is something to be said about those who play games, who try to just. Statistically speaking, the likelihood of successful completion, the longer these cases sit out here, has a direct proportion into how well they complete these cases. Your case is now 365 days old. We set case up for trial at 180. That's how long of games have been played here. So you have a contract now? Rick,
Yes, Your Honor, I just received it.
I'm going to reinstate and I'm sending him for a drug and alcohol test. I'm not going to make any decision on what to do, but I want to see what's going on and I'm hoping that he's clean, but I'll make a decision at that point. But I'm going to reinstate your bond. I'm sending you for a drug and alcohol test and then you're to be back here tomorrow. Do you understand? Okay, so that's what we'll do. And I'll see you back here tomorrow. If you cannot be here, you can zoom in so that you don't need to be here physically in person. If we do, if we do reinstate and we do continue, he's got a week to get everything done. I'm not going to reset this case more than a week. If you don't have it done within a week, then you will be put to trial or you must accept another offer. But I'm not giving you any more than a week, regardless of anything in this case. Do you understand?
So I need to appear tomorrow. I can appear via Zoom to.
Absolutely.
verify
Yep.
results, and then we'll reset for a week to allow us time to get.
Yep. If it's clean, then yeah. Okay.
Your Honor, my phone's about to die. It's.
Okay. I'll hit you up next.
Attorney Belinda Brown for Usman.
If you ever take off again, I'm going to add multiple zeros. Thanks. Okay.
Yes, Your Honor. I'm on Zoom and my phone's dying. I didn't want to cut in at all.
You just
but-
want to reset?
Yeah, Your Honor, we're in the middle of a kind of a informal pretrial diversion. My client is doing the things she's supposed to do. She's done some of them, and this was the halfway
Your
point.
case is 100 days old. I'm happy to give you more time, Belinda.
Oh, thank you. Yes, Your Honor. I was hoping if we could get to maybe early September or late August, we can wrap the whole thing.
We're around the third week of June, or no? I mean, sorry, July. So I'll reset you to like mid-July.
Okay, how about the 15th? Would that work?
You want July 15th?
Yes, Your Honor.
Bear with me a second. Let me check with the boss. Hey, McLean, I'll go over there here. Let me thin out this and then I'll head over.
Around you.
Yeah, I'm coming.
It's the same thing.
So I'm just gonna, and I'm still.
Yes, if you don't mind, so July 15th, is that okay? For bottom of page 13,
What day?
July 15th?
Yes.
Okay, we'll set you for that day.
Thank you very much, Your Honor.
It'll still be waived as well, okay?
That's perfect.
Okay, all
Hopefully
right.
we'll have all
Take
our
care.
ducks in a row by then. We can wrap it up. Thank you, Your Honor.
Your case is young. We really don't matter. Okay,
Okay.
thank you.
Thank you.
Guess who's back? Back again. Guess who's back? Is that what it goes? Mr. Lestrap, you were placed on probation for evading arrest or detention, and you've now picked up a theft, and then you picked up also a felony theft. Is it true or untrue that you have violated your probation? I'm going to find that it's true. You're charged with theft here yet again. The agreement that you have worked out is 30 days credit for the 40 days. Is this how you understand the agreement? You were giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Is this how you understand the agreement? How do you plead to the offense of theft, guilty or not guilty? I'm going to find you guilty, sentence you to the 30 days in jail, give you credit for the 40. All right.
Thank you.
Good luck. Okay, counsel, you ready? Hi, good morning. Thank you for being patient. Oh, great.
Right, it's some report. I don't see it as something.
Okay, let's do it.
All right, I'll speak with you at this point.
So I think that,
You will have to do the orange. If he does decide to use those regulations. That's what the.
so they're doing a PTI? It's just a straight probation, right?
Well,
Yeah, I think sober court is probably the right.
I just got this, and so I thought.
The case is old though, right?
Well, he was in the second charge.
Let me see, let me see how old it is. Oh, you got, well, it's 190 days old, so I guess set it a week. Let us know if you want to do it. If no, when is the next orientation? He needs, so what happens is he needs to go to the orientation and then he decides whether he wants to do sober court or not. If not, then we got to do something else. Thanks. Phil. Nice. Oh, wonderful. Great. So that's really close. So let's set it for, I guess, Monday, the 8th. And then if he says yes, then we'll send him to orientation the next day.
Okay.
Great. Okay, for sure. Okay. Hi, Alan. Thanks for being patient. What's up, buddy? Yes, what are we doing?
I don't know, Your Honor.
Is he here?
He's here. He's come every time. He say that.
Yeah, yeah.
Well, the last trouble.
You had him evaluated, no? Okay, well, that's a problem. So he needs to decide today what he wants to do.
On May second, he was sure.
So he needs to take the deal today?
That's why he was. Remember, we had to get the interpreter. and-
Is the interpreter here now?
No.
Okay,
So,
so,
the interpreter may have been available, I think, last week, whatever, but. that was an
so
issue.
can you ask Ramona to see what day this week we could do the interpreter and then we'll have him come back this week?
This week?
Yeah, this week. I'm not, it's 250 days
Yes,
old, man. I'm not doing the long resets anymore. So let's pick a day this week. He's got to come back and then we'll talk and you ask him if he wants to take the deal or we'll set him for drop. If he says no, well, we're going to set it for drop, but there's just no more. If it's on him, he didn't want to show up, then it's on him. But yeah. It only takes 24 hours a time for us to be able to set the Master Word only needs 24 hours to be able to get an interpreter. So and Swahili's not something that's too far out that would. It's not a dialect that they'll have trouble getting someone, you know? Ramona,
Yes, sir.
on Silamani,
Okay.
we need a Swahili interpreter. Please.
Now,
No,
when?
maybe 2 days. This week, maybe Thursday. Let's set it for Thursday.
Okay.
But we were trying to have him evaluated to try to do PTI. He doesn't understand anything. Alan set him for an eval. He didn't show up. So and the case is so old that I'm not doing long resets. So, but we need an interpreter so that we can finally work this thing out.
Okay, I'll have one here,
So we'll set on for Thursday.
I have a piece of.
Yes, of course. Absolutely. Well, can we get one by tomorrow?
I can try, yeah. Yeah.
At a minimum, they can zoom in,
Okay.
you know, okay. Hopefully.
Yes, Your Honor. Is it gonna have to be in Dare County on Thursday?
There's no problem. No, don't worry about that. We'll work around you, but I just don't want to do any more long resets. It's just,
So what time, about 10?
10. Yeah. You cool 10? Okay, so let's set it for 10. We'll wait for the interpreter and then have your guy come here, let him know he's got to be here, and then it's clear trial.
Yes, sir. Your Honor.
Yeah.
Thank you.
Okay. Hi. Yes.
I've been off docket, ordered for a motion to substitute for Miss.
I signed it already.
You did?
Yeah, yeah. It was a PDO one, right?
Yes.
I signed it for you already.
Yes.
Yes, ma'am.
Thank you so
Yes,
much.
ma'am. So I guess where'd she go? She left. We can walk with me, 6 real quick.
Is this
Oh, yeah.
Yeah.
Almost outfit of ours.
Well, that's one of them. Everybody else, yeah, she has to, now that she really. I think she. No response to the 15 days. Sheriff's office. Validate, we want to validate, figure out. This person's technologies because we cannot. So. He has to present, he has to know. Insurance, but I can't be all. It's like, if I make a mistake, I make a mistake, I don't have to shame things, all that kind of stuff. I can't do this job as well, I can do this job great, so I can do this for the. All that.
This is all the money, come back.
But you still want all of these.
Yes, you carry your. Don't leave it somebody, Brandon. Somebody. Don't leave it. If it's still.
That's the one good thing. That's not playing. That's what I got.
I don't know, I didn't feel like do it like, normally the way that it is.
He's fortunate.
Whatever, whatever, recommended. Design will do better for 5 years and trying to. Oh, yeah.
He was convicted and that's.
Well, I think
Hey there.
I know where if they don't have it. Staff sometimes are. Where you weren't hearing something on just check in again. Sometimes they'll just. Sometimes it's just a matter of. I'm not going to. So that is extreme. Oh, yeah. Okay, yeah. I think there's that. And so, but those are expensive. Can only be like 3 to 5. So, usually also by somebody helping you. That triggers something. Yeah. So like this one, I'm not gonna worry about. And that's where we're at. So. So.
It's just, yeah, you're here. Yeah. Is that? I like those. You guys know Judge Fleischer from that. Yeah. He's for 6 years. Okay, yes.
Yeah, what I'm concerned about is to make that number now. In the construction process, how they want to like finance Christian, you know what I mean?
Yeah. Okay, so I'll leave it.
I can look at how now. And then there's some deliberation of
So.
I'll think about
Hi. Amy.
There is that condition for this. Yeah, because now we just, they go on this case at the start, they don't know what this thing is. They're not responsible for what they're unfortunately, what's going to go there.
Oh, okay. I forgot. Okay. Checking the notes.
Easy.
In July. Tuesday or Thursday.
Yeah, I'm still gonna get that, then, well, hello there. All right, nice to see you this morning. I will be here once again, I saw that. Okay. My mistake. My apologies. Oh, that's. Yeah. That's not good. I thought about it. Like, wait, you're crazy. So, yeah, I was and double check that she. Yeah, because that's gonna be one person. Yeah. You know. Okay, so. Let's talk about yourself, girl, yeah, so. I can't change this. I got to skip through my letter, show me the exception for the courthouse. I don't remember what they said, definitely about business. So I'll take a look. Are you here now? Are you here? Okay, I saw John down there. You're a nice guy. Like, camera part.
Oh, yeah, buddy.
Where did I get? And where does the library go? That was great. He's had a time with that. Like, there's a lot of. There's too much.
That's big work as far as.
I think when I first came in, I was so skeptical.
You want doing training?
Yes.
Okay.
And then. I think it's. And I was like, all, not at all.
I said, yeah. Pretty good. I pointed to the judge, and some guy was like, don't do that. And well, I'm like, that's not him. So that was all. Incredible. And so I was literally like, yeah. The lady like straight up said, so. I did, I looked at her and said, I just stupid. She was not. I mean, the thing she said out loud.
Did everybody? Why are you sorry? So we're on board. Yeah.
They're pretty high, it was like 3 point.
Yeah. Yeah, but she you do that when you don't. Oh, no.
I think we've never seen keyboard where it doesn't remember. I think I'm with all of our records.
It's long.
Dumb things.
No, it's not big. Yeah, that's what here.
Yeah.
So your son's he's gonna man where to go. Oh, he's going.
We get a lot of like, my wife sees this as an annual destination, I'm like, no. That's, Galveston is an annual. Thank you.
No.
We may be Okay, I haven't found any suggested change. Oh, we didn't have this kind of- It's always, let's read it. Health day. Let me get the fine.
I'm with now. Are you going busy Monday? Pretty much done with the business. Can you go to lunch in a little bit?
No, it's
Marty, I'm gonna throw you into this motion and you're going to word when you can raise your right hand. So she's got, you swear to trust with us not for filling in some waivers.
Let's do them both. Come on, bring him up. Yep. Gray and Journey, come on up. Gentlemen, who's Mr. Gray? Both of you have worked out, or both of you are charged with criminal offenses. Both of you have worked out agreements to now dispose of these cases today, entering into what's called a deferred adjudication. This is a type of probation that If you complete successfully, you do not end up with a conviction on your record, but it doesn't get dismissed. You cannot tell people it gets dismissed because it doesn't. If you complete the probation successfully, there's no conviction. Do you understand? There's a big difference between the two. You need to understand it. So, Mr. Gray, you are charged with the assault of a family member. You're facing up to a year in jail and or a $4,000 fine. And Mr. Journey, you are charged with theft. You're facing also up to a year and or a $4,000 fine. The agreement both of you have worked out are deferreds. It's a 1-year deferred with, you must do an effective decision-making class, 8-hour anger management class, 20 hours of community service. Does the complaining witness want contact? Please. The important thing that you need to understand, Mr. Gray, is that there's an affirmative finding of family violence. That means this thing is going to trail you for the rest of your life. If you ever pick up another assault like this, and it doesn't have to be a drag, beat the hell down, no. Grab someone's arm and squeeze it up to where it hurts. You may be facing up to 10 years in prison, a minimum of 2, a maximum of 10 years in prison on a 3rd-degree felony. This can be used to enhance your punishment on a 2nd for up to 10 years. Do you understand? There is, like I said, the affirmative finding of family violence, so it's enhanceable.
We didn't specifically ask the complainant if they would like contact.
I'm going to order no contact at this time because I don't know if she wants contact, so no contact with the complaining witness. You are also not to be in possession of any weapons, no drugs, no alcohol, random testing. Is this how you understand the agreement? Mr. Journey, your agreement is for a 6-month deferred. Also, you must do an effective decision-making class, anti-theft class, 10 hours of community service, and restitution of $1,030. I'm telling you now that I'm going to hold you until the restitution gets paid. I've held people for 3 years to get restitution. If you start playing around, we will issue a warrant for your arrest. A motion to revoke will be filed and you will be facing a year in jail. But I have the authority to put you in jail for a couple days, bring you back out. We'll continue it. You play again. Could be next time a week, next time 2 weeks, next time. Do you understand? People should be made whole is the fair thing to do. Both of you are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers, your right to be arraigned, charged, read in open court. If you guys are not citizens, there are possible immigration consequences. You could be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you're stuck with us until you complete it or it gets revoked. If you do something to violate this agreement, like you test positive, you pick up a new case, don't do your stuff on time, we issue warrants, put you in jail. We will have a hearing to determine if you violated the agreement. If you do, you're looking at each a year. Is this what each of you want to do? How do you plead to the offensive assault of a family member? How do you plead to the assault of theft? I'm sorry, the offense of theft. All right, I'm not going to find each of you guilty. I'm going to follow the agreement, sentence you to it. Taking off is about the worst thing that you can possibly do. If you ever have any issues, you can come back and talk to us as a reward for you. If you do well, meaning you don't test positive, you're nice to the probation officers, get everything done that you're supposed to, I'll take you off in half the time. So you can be done with this thing in 6 months. You could be done with this thing in literally 3 months if you get it done well and do a bang up job. Each of you understand. All right. Good luck to each of you. Take care. Hi.
Hi, Judge.
What's up? Is this the one that's still going? Okay. Oh, we're doing the plea. Yeah, come on. Yeah. Are you ready?
I'm ready. Here's the certified days. They want to do the date of September 10th.
Yes. Now, I was gonna add 2 things on that, Judge.
I'm okay. He's on probation, right?
Right.
Yeah, I'm okay with it.
Okay, because he says, come over here. He has a calendar and believes that that's the day that he's gonna have vacation.
Well, no. It's not believe. This is a hard date. You can't come back and try to change it at a later date. It gets into the conditions. It gets into the judgment. This is the date that needs to be. I can't change this later on.
You cannot?
No.
I'll take September 10th, that date.
Yeah, I mean, that, if you want that, I'm okay with that. Just, but understand that if that's the day you pick, that's the day you pick. I can't,
I'll have them.
there's no buyer's remorse here.
I'll ask the supervisor that work.
Yeah, just make sure.
And by the way, Judge, does the court allow, different, go two different times to?
No. It's all one step. Yeah, it's just, it costs too much for the sheriff's office to do it. So they don't do weekend or they don't.
And we haven't done the plea yet, but as long as we're on the subject, I was going to ask the court if we would consider doing a house arrest during.
No, it's a DWI second.
Yeah.
No, it's.
He's got some, he's disabled, he's disabled according to the veterans, application.
If you go out there and you kill someone, do you think they care if you have a disability? No.
No, I'm the one that's asking, Judge.
I understand, but I want you to understand that the law, we just had a deputy here that we worked with for many, many months killed this past weekend because of alleged negligent driving. Every single day, someone dies in Harris County because of an alcohol-related issue. Look at me, because of an alcohol-related issue. It's so not fair. When all you have to do is literally take an Uber for $30. Mr. Trevino, and all the money that you spend on all the court cases so far, $30 in an Uber will get you to wherever you want to go in this life. You understand? It's not hard. It's tucking your tail, recognizing when, even if you've had two, it may be too much, and taking a $30 Uber.
But no, he's not going to play. Yeah, I mean, God willing, not, I mean, we've talked.
You know how many times I hear that?
I know.
So the agreement that you've worked out is you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is 1 year in jail to be probated for 1 year. As part of the agreement, you will go into Veterans Court. It's only 1 year probation, not 18 months.
Yeah, that's 1 year I have it. Veterans Court.
Is that right? I thought it was an 18-month probation on Veterans Court.
It says 1 year. Make sure it doesn't work, right?
I know that you're trying to do the best thing for your client. I understand that, but let's say that on Veterans Court, it says a year?
Yeah.
Okay.
Yes, sir.
So as part of the agreement, there's no drugs, no alcohol. You must maintain a guardian interlock, do any classes associated with it. A repeat offender DW education class. No breath test refusal, meaning while you're on probation, if you were pulled over, an officer asks you to submit a breath test, you must do it. This is a second. I have to suspend your license. I will do it for a year. Do not drive until you get a license. Have any questions? You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this. If you violate this agreement by testing positive, picking up a new case, driving without an interlock, or driving without a license, we issue a warrant for your arrest and you are facing a year in jail. Do you understand? If you have any issues, come back, talk to us. We can work through anything, but the worst possible thing you can do is just take off. That's an instant warrant or picking up a new case. All right. Good luck to you, sir.
There's the only question I have.
Oh, and to turn in, what day, I gotta write this down. What day?
As far as he's got a standard license. On. What
does he have now?
Correct.
Does he have a portable device?
No.
Okay, once he gets the portable device, because he can't drive because it's a suspended license, once he gets a portable device, I'll take it off.
Okay, one other thing, Judge. Is there any way you could, lessen the suspension period of his license?
It's a first. It's a second. It has to be.
His license was suspended as a result of the ALR.
I'm not, no.
He got an occupational license and he's complied with all the conditions, Judge.
Great. I mean, if he's got an occupational, then I'll honor the occupational, but I'm gonna suspend his license. He's got an occupational, so we'll have to amend it.
Okay, the occupational expired already, but you granted him that license, you granted him the occupational, he complied with all the terms and conditions.
Okay, if you want to file another one, I'm happy to do it,
Okay,
but I'm not gonna, it's a DWI second. He needs a license suspension. It's mandatory under the law. So I'm gonna suspend your license for a year. I do it on every case. I'm not
you will
gonna,
grant him an occupational. if
as long as he's in compliance with everything, then yes.
That's good, thank
Yeah.
you.
Judge, the cases get transferred to court too.
Maybe transfer after.
So it gets transferred to 10,
Yeah.
file the occupational in 10,
Okay.
and then it shouldn't be an issue.
Sounds good. Thank
Yeah,
you.
I just let her know what I was, I don't think it'll be an issue for you.
Okay.
Yeah, just let me know if it is.
Appreciate it.
Okay.
Hi.
Hi. Uh-oh, double team?
Well, I was triple team this morning, Judge. But, so you're here on Ramirez.
Yes,
again.
yes.
Okay, my position is that based off of the four corners of the dams, it states that the only description I was getting was a Hispanic male at 44 years old. And they went to, the officers went to the location, they said he wasn't even at the residence. He was about 3 to 5 feet away. This is a residential neighborhood, so.
Well, 3 to 5 feet's not that far. I mean, it's really
I understand,
where
but
you
it's
and
a
I are
neighborhood
is
where-
3 feet.
Absolutely, Judge, I completely understand that, but it's a neighborhood where multiple houses, so he can be 3 to 5 feet away from. If there's 2 houses next door to each other and he's on the sidewalk, I mean, he's 3 to 5 feet away. Essentially, could be even from both houses. Aside from that, Judge, when officers approached and they tried to recontact the person that made the report, they couldn't upon arrival. So they just see an individual, a Hispanic individual. And they said he matched the description. There is no other descriptors, not clothing. There's tattoos on my client's face. They could have said tattoos. There was no other descriptors but a 40-year-old Hispanic male.
But
And based off of them just initially just detaining him as soon as they get there, I know, they were saying that they can do that if there was violent tendencies that were reported to the officer. However, the only violent tendencies that says was threats to the mother. It needs to be, those tendencies need to be more specific, such as, does he have a gun on him? Or.
threats to the mother is pretty specific.
Threats to justice, it could be as simple as, the threat.
But it's enough to investigate,
A
no?
threat to, yes, to investigate and to actually reasonable suspicion to detain him. When.
And that's
the only
exactly what they're doing,
The
though.
only description is a 40-year-old Hispanic male. It could be thousands of 40-year-old Hispanic males in this general area.
But there's only one in the area at the time, right?
That's
You don't
not
have,
stated, that's not stated in the names. We don't know. It could have been other people there.
I get
It's
it,
silent.
but
And so now we have to
riddle
know.
me this. A person can go up just any Joe Schmo on the street and ask him a question. There's nothing wrong with that, right?
They can ask him a question.
Okay.
Correct. There was no questions even asked my client.
Well, that's what I
They-
was alluding to the last time, because I was under the impression that they just go up to him and they just arrest him. As soon as they see him, they get him, okay, turn around, here's some cuffs.
That's exactly what's happening inside.
But
with
they're
the president
saying-
Adams. With the dentist stating, that's exactly what happened. They see a male walking away and they detain him. That's exactly what. the
Well,
dentist-
detain is not handcuff.
They said attempted to detain him, and he started to pull his left arm away. That's handcuffed.
Did they just go up to him and start to handcuff?
Judge, we actually got audio on camera.
If we're gonna go outside the four corners of the dam zone, we have to do an evidentiary hearing. Because we're gonna be using.
Well, that's what I was saying.
We're gonna
Do you
use-
want to do it tomorrow and see?
There's nothing that says he used any force against the officer. To just be initially detained, he was.
Well, but they said they initially tried to detain him. And then what?
It says when they tried to detain him, the defendant multiple times attempted to pull his left hand away
as he stepped away from the officer.
So they're trying to arrest him then?
They were trying
Are
to
they
detain
not?
him, Judge, so,
Well, okay,
yes.
are you telling me that they're trying to arrest, or trying to put handcuffs on him?
They were trying to detain him, but as I mentioned, Judge,
They're trying to put handcuffs
Your
on.
Honor, may I step in?
Judge, again,
Sure.
they spoke to him prior to this. I'm just reading the portion out of it.
That's what I want to know.
Yeah,
Are
definitely.
do they just go up to him and start putting handcuffs on it? Or do they talk to him and then they, at that point, they say, okay, well, he's trying to, evade
No, Judge, they go
by
up
giving
to
us false
him.
information?
They go up to him, they speak to him and attempt to speak to him, and while they're talking to him, that's when he begins, they try to detain him, and that's when he begins to pull away. So they are speaking to him when they walk up.
Did he
And you can see
get-
that in the body on camera, they indicated that in the officer's report, that it wasn't just, she asked the
Hold on.
question of whether or not they spoke to him, so I'm answering the question. They spoke to him before they tried to detain him. It says, clearly in the officer's report, which is available immediately, that the officers got out of the vehicle, they saw the suspect matching the description that was provided. The officer Otero talked to the suspect, and while the other officer talked to the mother. It is at that time that they tried to detain the suspect, and that's when he started resisting and pulling his arms away, Judge. So they didn't just immediately go to detain him without speaking to him, they spoke to him. That is in the body worn cameras, in the officer's report, it's listed that they did try to speak to him.
But we are doing probable cause based off of the dams, the four corners of the dams. You are gathering evidence from the offense report and from body cam, which.
Well, because it's not very clear. I'd like a little bit more
So part of
clarity.
the dams, it states that they get there, they see him walking away and they attempt to detain him with handcuffs. And that's when he's pulling his arm away. If we're sticking to the four corners of the dams, that's exactly what we're presented with.
Well, I'm not sticking just to the four
Okay.
corners. I'm
Well-
also looking for a little bit more clarity too, because we can. If you look at the body worn camera and it looks like they just go up to him and they just arrest him without doing any kind of questioning or doing any kind of investigation, then I've got a problem. If you see it and you show that, but I think that officers can go up to a person and just ask them questions, especially when they've got a report of someone who is dangerous. The mother's filed a report.
I totally understand, Judge. Just for procedural purposes, so when we're doing probable cause, we're able to go outside of the
I
four
think
corners
so.
of the dams, if we can set it for an actual formal probable cause hearing.
Sure, I'm happy to do it
Okay,
anytime you
she's
want.
bringing up things that are in the office report and body cam that is not strictly within the four corners of this dams, so,
You can too.
okay.
I'm telling, that's why I said, if you want to look at the body cam and tomorrow, the next day, you have something that adds more credence to you, then bring it.
Okay,
I have no problem finding probable cause on a case. I mean, what's right is right, what's wrong is wrong. But an officer can clearly go up to someone and start talking to them, and that's all I want to know. If he goes up and say, talking to them just because, hey, we're trying to figure out what the hell happened here, because
my other argument, Judge, is that to find probable cause, it needs to be like a sworn, from a sworn statement from an officer. The offense report is
Well,
not a sworn statement, so.
at this point, it's just reasonable suspicion. We're doing reasonable suspicion to see if criminality is afoot.
So if that is fine, if we're doing reasonable suspicion, however, they're putting handcuffs on my client. That's an arrest.
After being questioned.
They've never questioned, well, the damn state that he wasn't questioned.
The OR says it was.
Okay.
Look into it and let me know. If you see something different, I'm happy to, revisit. Or if you want to set up for a formal hearing where we can bring in, but I want to give both you guys the opportunity to look at the video and then bring it up. And I'm happy to do it.
Okay.
Whatever day you want.
All right.
Thanks. Yes, ma'am. Okay, are you ready?
I am Joe.
Hey,
This is actually a quick matter.
yes.
They also put, bond condition here this time.
Okay, tell me, what's the word? What's the good word?
Well, this is the second video on this particular.
On this gentleman here?
Yes.
Okay, come up, sir. I didn't realize, I guess we left before addressing it. Let me pull up does he not have a lawyer?
No.
That's a
And
problem.
also, there's another issue in that he doesn't have a car, so there's some issues with portable and so we just wanted to.
What is your cause number, please?
It is, Judge, it's 259-3145.
Mr. Walker, you're charged with driving while intoxicated, second offense. It looks like our first bond violation report was filed in January. And now, or is that the only one that we have?
Yeah, I just.
Stop. You have the right to remain silent. Exercise that right. So I see that he has a lawyer. Carl Pruitt's been appointed to represent him. Oh, is he on probation or something?
No, I was double checking with our CLO. I mean, sorry, our pretrial services. About his attorney. We need to go vote on that. You know, we have a violation and I believe there might be some issues with bond. Or not bond, excuse me, with the portables or the device.
But I'm showing a lawyer. I'm showing Carl. Huh?
Oh, the lawyer, apparently the lawyer never showed. I think that's what the issue was with pretrial. The lawyer never showed.
Yeah.
He was supposed to get a scram.
The official law, this is Carl Pruitt, not in the present.
Hey, Carl, it's David Fleischer. I'm calling you with regard to a court 6 case, cause number 2593145. Would you mind giving me a call when you get this? Thanks, bud. Bye. I can't address anything until we get a lawyer. So why don't we do this? Why don't we set it for tomorrow? And if Carl's a no-show tomorrow, then we'll reappoint and then we can address it tomorrow. In the interim, let's send him for a drug and alcohol test now. And then we will address that tomorrow as well. So he's supposed to have a device on now. Does he have one or not?
No, he was given magistrate conditions, but he's never given a device with that. That's the main problem we're having, since it's at DWS.
Carl.
Good, Judge.
Hey, you got a sec?
I'm here.
I am now, so Judge Andrews is out and I'm taking care of her docket. And I've got a Mr. Walker here who's charged with a DWI second and you are appointed on the case. Do you have a sec to talk about it?
He blindfolded on me and,
This is correct.
I didn't file a motion to withdraw. I didn't know that he was on the docket, had been rearrested, he was on the docket today. I'm not even in Harris County today. I got a doctor's appointment.
So can you be here tomorrow?
I can be there tomorrow, yes.
Okay, so what I'm going to do is I'll put it on for the docket for tomorrow. He has bond violations again. In January of this year, in December of this year, he was supposed to get a scram. He has not gotten it since, as of today's date. I think there are further violations from what you say.
Possibly, Judge. I think Judge sent for
I think he primarily has financial problems.
We pay for everything though. So,
Yeah.
but anyway, so what I'm going to do is, can I give him your office number so that you guys can somehow get in contact? Is that okay?
Yeah, he knows my office number.
Okay,
But yes, you can give it to him.
okay. And then you'll be here tomorrow though, for sure, right?
Yes,
Okay. I'm ordering you to come here tomorrow. I'm ordering you now to go take a drug and alcohol test. We will get the results of that tomorrow. And then we can revisit tomorrow. But I can't, I don't want to do anything without the lawyer present, especially if I'm going to revoke his bond and put him back in jail. So you're ordered to be here tomorrow. If you fail to appear tomorrow, and if you ever fail to appear again, I'm really going to go bananas on your bond. Do you understand me? Okay, we'll see you tomorrow. Thanks, Carl.
thanks, Judge.
Okay. Bye.
Thanks, Judge.
Hold on.
That was just our biggest thing.
So, yeah. Can you, if you don't mind, asking Caitlin to give him a new reset for tomorrow? Circle his phone number so that he has it, so there's no excuse. It would probably be a good idea for you to get in contact with your lawyer today so you can go through everything so you guys are prepared for tomorrow.
Okay,
You want-
I have the number in my wallet too.
We're gonna give you a copy now of a reset with tomorrow's date with this phone number, so there's no excuse, because I don't want you to come back, oh, I lost my wallet, I can't find my phone number, I got this, I abducted by aliens. No, no excuse. See you tomorrow. Thank you. Ramona, come on, man.
You saw it? Yeah.
Hey, it's 1:05.
Norman, on page 20.
2501. Did we ever hear from Alford? Alford? I'm sorry. No, Hall. Okay, so the Hall gets revoked. 7502. Hey, you need to sign something? Okay. Are they in mine or yours?
In yours.
Okay, thanks.
Thank you.
Yes, and thanks for coming. Sorry, I'm sorry we forgot about it.
Page 10.
Yes, 7502.
That's great. They got Elijah 14. Oh, did I? That's not good. 413.
A lot of people were saying the trials may be approved.
Yeah.
Yeah, I think of them as a thing that is something you look at all that, but I got a point like that, right? Yeah, I'm seeing it, not supposed to be that.
Good try. Good try.
Okay, I'll try to go to it.
Okay, I'll be excited.
Thank you.
Thank y'all. See y'all later.
Okay.
Bye, Judge.
Bye. See you later. Have fun.
Because I'm shy.
Toronto is not on your docket.
Mm.
One that was supposed to.
Yeah.
sign the bond condition.
What's the cause number, please?
262.
Okay,
1538.
2501.
And then Smith and Stokes, page 28.
2501 on both.
That's it, guys.
All right. Guys, we're done.
Thank you, Judge. Thank you, Judge. Thank you.